Good Saturday morning, afternoon, evening, depending upon where you are in the city. Welcome to From the Halls of Justice. We are very fortunate today to have in the studio with us, excuse me, a very special guest. It's cold in here, but we're loving it. A very, very special guest, Murvet and I, my colleague, Murvet Arnstein, who is the other producer and host of our show. We have with us Supervising Judge Robert Schnider, and he's retired now, but he was the supervising judge of the Los Angeles Superior Court, which is probably one of the largest courthouses in the country, if not the largest courthouse in the country. And we are very honored to have him with us today. We're going to talk about surviving trials and litigation, and he knows all about that. So Murvet and I are going to grill him and make sure that you have all the information you need to survive the trials. Judge Schnider, thank you once again for being here.
Yes. You're welcome. Let me say I was the supervising judge of the family law department only. Still a very large department.
Very large department.
Well, thank you for coming.
We are going to start off with new legislation that adopted Elkin's recommendation. What is it, and how does it affect the courts?
Over the last few years, there's been considerable concern about family law trials and attempts to use declarations and written documents instead of allowing live testimony. There was a case called Marriage of Elkins that the Supreme Court heard, and they reversed the ruling in Contra Costa County that limited people in the ability to give testimony. When the Supreme Court made its decision, they also said there needs to be some changes in the way family law cases are handled. So they started a commission called the Elkins Commission, and they made a number of recommendations. The major ones limited the use of attorneys for children. Those attorneys used to be able to give lots of information that wasn't admissible otherwise. And they also required that all trials be conducted giving live testimony, and that live testimony also be used at hearings for temporary orders. So the change that's happened is that trials are taking much longer, hearings are taking much longer, and courts are getting substantially backed up in terms of their ability to resolve cases.
So it's live testimony now versus declarations.
In many cases, the court still can rely on declarations if the parties agree, first of all, and secondly, if the court finds a good reason to just use the written declarations as opposed to the live testimony, the judge can make that decision.
Okay, so what sort of cases do you see in private judging trials in mediation?
Well, there are two different things, mediation and the trials. Every sort of case comes through mediation. Typically, the issues are property and financial issues, but I've also had many custody cases as well in mediation. In trials, it's generally the longer trials where the lawyers know that they aren't going to be able to get enough time in the courthouse to try the case the way they want to, or it's going to be delayed and stretched over a number of months. So larger trials frequently involving financial issues, but sometimes involving large custody issues such as move-away cases.
So what are the advantages of a settlement over trial?
Trials today, and really always, are almost always the result of some sort of failure. Most cases settle. The ones that don't settle fail to do something that would have brought them to a settlement. Someone is unreasonable, someone has a view of what they're going to gain that's really not properly reflected in the evidence. Trials are almost always hugely more expensive than a settlement. Trials put your fate in the hand of a judge instead of you being able to make the decisions in your own case. And generally speaking, any trial result is worse than the parties would have ended up after you take into account the attorney's fees and other costs by reaching a settlement at an earlier stage. Every now and then someone hits a real home run, gets everything that they're hoping for. That does happen occasionally, but most cases end up somewhere in the middle, and when that happens, the last settlement offer that was on the table for either side is usually better than the result at trial.
Wow. Now that's good information.
Yes.
All right. So this is going to take off, I guess, from the Elkins situation. One of the questions I have is that we hear a lot of conversation about how one spouse, and you mentioned this, is not informed about financial aspects of the marriage, how the business runs without informing the other what's going on. They buy and sell assets without getting consent from the other. How do California courts in a dissolution divorce case treat these actions?
Well, generally speaking, we have what's called joint management and control of assets in California. Each party has the right to make decisions about the community assets. But typically, in most families, one party is running the business if there is a business activity, and that party is typically making the decisions. Under our laws, if the other party, the out spouse, we typically call them, wants to get information and asked about the information, the party who's running the business must share it. There are statutes in our family code that say you must share that kind of information. More typically, however, the party, the out spouse, is happy to let the spouse who's operating the business just do it, to make all the decisions. Typically in our society, that's frequently been the man, the husband. Not always these days. Often women are running businesses now. But unless that person does something that is intentionally harmful to the other side, they're going to be able to make the decisions for the business and continue operating the business even after the parties separate, unless the court intervenes and says that they can't do it.
So tell us, what is an income and expense declaration, a schedule of assets and debts?
In order to make divorces a little bit easier on everyone, a number of years ago, the court began developing forms that the parties could fill out rather than each side making up their own documents. So one of the forms that each party has to fill out is called an income and expense declaration or financial declaration, Form FL 150, Family Law 150. And on that form, they list their income for average for a year and their income for the last month, all sources of income, wages, self-employment income, asset income, that's passive income. They also are supposed to list the total value of their assets, and that's on one page. Then on another page, they list all of their expenses in a variety of categories: mortgage or rent, food at home, food out, laundry and cleaning, education, automobile, insurance, various categories. So then the court, trying to make a decision about support issues, has a general idea of what everybody's income is and what everybody's expenses are. Well, the parties are supposed to fill them out as accurately as possible. They aren't always. People make mistakes, people lie, and that's why we have cross-examination at hearings, and that's why we have what's called discovery, where you develop documents like getting bank records and other records to challenge the information on the financial declaration. The Schedule of Assets and Debts is another document where our legislature decided divorce cases shouldn't be by ambush or surprise, that each spouse has a financial obligation, a financial duty, a duty of good faith to the other spouse, and they're supposed to list all of the assets of the marriage that they're aware of and all of the debts of the marriage that they're aware of. So everybody can go into the divorce process, the dissolution process, knowing what they're dealing with and how those assets ought to be divided and the debts ought to be divided. Once again, people don't always agree that the other side's listing of assets and debts is truthful or honest. That's where the cases get more heavily litigated, where discovery comes in. But at least we're starting out with each side having an obligation to tell the other side what they think the facts are and what they think the assets and debts are.
So what would be a fiduciary duty that each spouse owes to the other, or to the court, and regarding their financial disclosures?
Well, each spouse has a duty of good faith and fair dealing with the other spouse that continues even after they separate, continues to a degree even after the divorce, their status is divorced, if there's still property to be divided, which can happen. You can get unmarried but still wait for a while to have the property issues all resolved. So until all the property is divided, they each have a duty of good faith and fair dealing.
So what type of disclosures are required by the court in order for the parties to obtain, say, legal separation, annulment, dissolution type judgment?
Well, the duties of disclosure on property issues are the same for all of those. Each party is supposed to advise the other party not only of the assets and the debts, to say something about those assets and debts, some meaningful information, and supply information about things like business opportunities that come along during the dissolution. Really what we want is to have everything put on the table and then have the parties be able to operate from the same set of information honestly about all the assets and debts. Of course, the cases that get litigated are the ones where one side is saying the other side isn't being honest. And we have some penalties for that as well. The court has the ability to impose sanctions against one side if they aren't being honest in setting forth the information that they're supposed to set forth.
Okay, so the money issues, we can delve more into that too, but besides the money in a marriage, unfortunately there are fallouts in war about children. So for custody issues, frequently there are conflicts between the parents. What is generally the best test that the courts look for to decide what would be in the best interest of the children?
Well, let me first say that most cases, the majority of our cases, the custody issues are solved before they get to trial, either just between the parties themselves, the parties working with their lawyers, and every case where there's a custody issue in the state of California, the parties are ordered to go to a mediation with a court mediator who is a trained professional, and the mediation service resolves a large majority of the cases that they see. Ultimately, maybe 5 or 10% of the cases end up coming to trial, and obviously those are the cases with serious difficulties or disagreements between them. The cases often involve a parent who is in some way damaged. Maybe there's some psychological problem for that parent. The cases involve substantial differences in the idea of how children should be raised between parents, which often led to the divorce itself. Those things are hard to put together, hard to mediate. And the cases sometimes involve abusive parents that one party is attempting to escape from. Courts have to have an obligation to look for what's called the best interests of the child. Not always completely easy to figure out, but in trying to figure out that, judges are looking for the nature of the psychological relationship between the child and each parent. Judges are looking for the safety factors. Is any parent toxic or dangerous to the children? That's really the first thing you look at. That's a small percentage of the cases in reality. So usually the issue that becomes most important is the nature of the psychological relationship.
So when this is going on in the trial, and if they cannot come to an agreement in conciliation court or the mediation for the custody of the child, does the age of the child have anything to do with the primary custodial parent and how you make a decision?
In the old days, before 1970, before the old family law, new family law was passed, there used to be something called the tender years doctrine, where there was a presumption that mothers were better for children of tender years. It was not really based on any scientific evidence, just a general understanding of our society at the time. And by the way, the understanding was different in prior years. There used to be a judgment that children belonged to the father, and they were always given to the father unless there was something wrong with him. Scientific research has shown that both parents can be adequate caretakers for children, and mothers are not particularly better than fathers, and fathers are not particularly better than mothers. So the age of the child doesn't matter in the abstract. Now, children have different needs and different tasks based on different ages and when they're growing up. And one parent might be better suited to covering that task and that ability of a child at a younger age, and another parent might be better at an older age. So in that sense, the age makes a difference, but only individually, for the individual child and the individual parent. There's no general rule that young children go with their mother anymore, or older children go with their father.
And that's the key word probably, is anymore, because in the good old days, yeah, where they did think that we were better parents at that tender age.
So how does the court determine the proper child support amount?
Child support in the state of California, and really every state in the country, is governed by a presumptively correct guideline. Every state has a different formula. California's formula is generally based on some scientific studies of some questionable value, but scientific studies of what an intact family, what percentage of their income they would spend on their children. Then the formula takes into account the net income of each parent, the amount of time that the child spends with each parent, and tries to apply that formula to the general finding of what intact families would spend on their children. So there is a complex mathematical formula. Those formulas have been put into various computer programs. People might have heard of the Disomaster, which is probably the most heavily used formula, but there are other companies that create these same kind of computer calculations. And so child support, to start with, is based on the judge inputting certain factors into his or her computer and punching out a number. Now, how you get to the certain factors is often disputed. What somebody's income, that's often a dispute. Timeshare is often disputed. Other factors can be disputed, so it's not just mechanical. And once you come to a guideline number, that number is presumptively correct, but the court does have the discretion to deviate from the guideline if special circumstances are present. Special circumstances might be something like a special needs child. Special circumstances might be something like factors that don't really fit neatly into guidelines. And the judge has the ability to make some judgment about that. But basically, we start out with the guideline and input these factors into our computers, and out pops a number.
Okay, then how does the court determine a proper temporary spousal support order?
Okay, in our computer programs, along with the presumptively correct child support guideline, the manufacturers of these programs also give us something called a suggestion for spousal support. And these suggestions are based on some rules of thumb that have developed over the years in various counties. There are 4 or 5 different rule of thumb guidelines in the state of California developed. They're identified by the counties that primarily use them. The Santa Clara guideline is a frequently used one. Los Angeles County doesn't have a presumptively correct guideline, but our judges frequently use the Santa Clara guideline. And the rule of thumb is based on the percentage of net income available to each party, taking into account the child support that's being paid. So for temporary support, when you punch in your numbers into your Disomaster or support tax or ex-spouse program, a proposed temporary spousal support guideline number comes up. And judges frequently use that, but have total discretion to deviate from that if they want to.
So, excuse me, how would permanent spousal support be determined?
Permanent support, however, is different from temporary support. You're, in fact, prohibited from using the temporary guideline, and the appellate cases say you have to build permanent support from the ground up. And we have a section of our family code, family law section 4320, that lists the factors that court has to consider. They have to take into account the history of work of each party, the income of each party's ability to work if they're not employed, the tax consequences. Domestic violence is one of the factors that the court can take into account. A number of other factors, including a general overall throw-in factor, anything else the court deems relevant. So in looking at that, you look at the standard of living of the marriage, what everyone will be left with after the support is paid. You take into account the tax factors, you take into account the child support, you take into account the expenses, the debts that the family has. In the end, for most families, other than the really wealthy families, nobody's going to end up living at the standard of living that they had during the marriage, because now you're separating two households, you don't have the economy of scale anymore. And basically you're trying to give each party the same level of disability. I often say we're not giving out, we're giving out a level of unfairness and injustice, but making it equal rather than giving out a level of justice, because we can't get to what everyone would like to have. Yeah. Everyone will be less than what they had. Everyone will be sacrificing.
Definitely.
Well, how long does child support last? And I'm sure our audience would like to know that. And how long does spousal support last?
Two very different standards. Child support initially goes to age 18. But if you have a child who is under age 19 and still a full-time high school student, the child support can go till they either graduate high school or reach age 19. 19 is the final cutoff. However, we also have provisions for adult support of adult children who are disabled from employment, special needs children of various kinds, so child support in that sense can go on forever. But for the vast majority of families, 18 is the cutoff, or 19 or graduation from high school after age 18.
But handicapped children, you said it could go on forever.
It can go on forever.
Okay.
Spousal support is different. There is no cutoff age or time. California has, by appellate cases and by statute, has decided there are two kinds of marriages: lengthy marriages and non-lengthy marriages. And we peg 10 years or more as a lengthy marriage. For a lengthy marriage, the court basically doesn't have the ability to terminate its jurisdiction to award spousal support. Might say the dollars flow for a number of years and then stop, but it always has to keep in its back pocket, the court has to keep in its back pocket the ability to come back and revisit that for a lengthy marriage. Under certain circumstances, the court can terminate spousal support for a lengthy marriage. Very rare, and the cases generally say just hold on to that ability even if you don't want to put any money in there. For marriages less than a lengthy marriage, under 10 years, the legislature has given the courts a suggestion. It's not a requirement, just a suggestion. And the suggestion is that spousal support normally should run for half the length of the marriage. So if you have an 8-year marriage, half the length would be 4 years. That's not a requirement. How you start judging when you do the spousal support for half the length of the marriage term is also up to the judge. Some people start from the day the parties separate. Some people start from the day the case goes to trial, even if support has been paid for a long time before that. In determining the length of spousal support for a short-term marriage, the court really has to look at the individual factors of the family, guided by what the legislature has suggested, this half the length of the marriage standard. And in addition, the court does have the ability to look into the issues of spousal support. We do have an expectation that each party, even formerly unemployed spouses, will do their best to support themselves. That's part of the statute as well. So a court might make what's called a Richmond order, based on a case called In Re Marriage of Richmond, where the court might say, okay, I'm going to order spousal support for 4 years. I'm going to drop it to 0 after 4 years with the expectation that the unemployed spouse will be earning enough to support himself or herself at the standard of living of the marriage. And then if they're not, they can come back to court before that 4-year period, or at some time after that 4-year period, and explain why they weren't able to earn enough to support themselves at the marital standard of living.
Now, this is what's going to happen during a trial. And I'm going to take just a second to, number one, mention two things. I would like to thank Mr. Richard Trugman for helping us. He was our ghostwriter on our questions today. And so thank you to Mr. Trugman. And also the fact that Judge Schnider, once again, is active. He took the time to come here today. He's also part of ARC, A-R-C, and that's it's based in Century City.
Right.
So I thank you for being here. I love the fact that you volunteered to help me with this.
My pleasure, Wanda.
How does mediation help in a settlement?
As I've said, mediation almost always saves the parties money. Mediation gives them the ability to control their lives. But couples who are getting divorced aren't usually on the best frame of mind to speak to each other. And if they go to a mediator, someone who's trained in family law, either a retired judge or a lawyer who practices family law, that person can help give them suggestions as to how the case should be resolved. They might have lawyers who are with them, or they might have lawyers who are consultants. The judge can give them, private judge can give them an idea of how the case might end up in court, how good their lawyer's theory is, whether the judge thinks they have much chance of success or what the chances are. And the mediator can also find ways to bring people together, to stimulate their cooperation, to stimulate their thoughts, and put in his or her own suggestions as to how to bridge certain gaps and what some solutions might be that the parties or the lawyers hadn't thought of themselves. It's very often helpful to have a neutral third party who comes in and takes a look at the whole set of issues.
Well, we've got 1 minute, so in order to wrap this up, in your opinion, for a dissolution for a marriage to divide the property, arrange the children, support ongoing, do you need a lawyer?
Many cases, the majority of cases today are done by parties without lawyers. There are self-help books. We have self-help things at court. But if you have more complex issues, really, you need a lawyer, at least as a consultant. It's a sacrifice that people just have to make to pay the fees that the lawyer needs to run their business. Generally speaking, in a more complex case, a lawyer is very helpful.
Well, thank you very much.
Thank you.
We really appreciate you being here. Join us here next week on From the Halls of Justice. And once again, our special guest, Supervising Judge Robert Schnider. Thank you.